In this video, we're going to talk about how Indiana courts determine the best interest of a child here in Indiana. The best interest standard, it's a vague standard, and if you're not familiar with custody cases or divorce cases in Indiana, you may need to understand a little bit about how it works. So we're going to talk about this in this video because if you're in a divorce or custody case, you're going to want to know what things you're going to need your attorney to know so that you can present these things to the judge so you can get a good outcome in your case. About me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and I help people in divorce and custody cases across the state. I would be happy to answer any questions you have at the end of the video. So the first thing is just why the best interest standard matters. And it's a standard that essentially just prioritizes the interests of the child, and it's a framework that the court looks at to make sure that all the different things are accounted for when they're considering the best interest of the child. And it balances the parents to parent their child versus the child's specific needs when growing up with the family. So the key factors, there's a lot of factors with the best interest standard. In the statutes here, it's 311728, and it's a lot of different factors. One of them is the child's age, the sex, and even what the child's wishes are. Things like how young the child and the sex of the child are important. They also look at the interaction and relationships of the child. When you're in a family, it's what's your family unit? Do they have siblings? Do they have step siblings? Are there other parent figures there? And then even broader, do they have relations like with grandparents, cousins, aunts and uncles, neighbors, close family, friends? Who's that community in your family who that child's around, and how does that impact the child? When I'm in a custody case, that's actually a really big thing that I like to talk about is who are these children around? Do they have a neighbor that's a best friend? And that's a very big impact. Do they have cousins that they're close with that they see every weekend? Do they go to a church that they have people they know that are beneficial for them? There's all these things in that interactions and relationships bucket that are important. They're going to want to think through. The next is adjustment to home, school, and community. So that comes into where your home is. Is it a safe place? So that comes down to where your home is. Is it a good home for the child? Is it set up for them well? The community around, or is it in a good school system? Do you know about the school system? Things like that. Next is mental and physical health of the parties. Are you able to take care of the child? Sometimes the child may have special needs, such as they have to go to certain kinds of therapy, or they have certain kind of treatment needs that you need to be familiar with. A lot of times you may have a child with a specific like ADHD or autism diagnosis, and you have to do certain things as a result of that diagnosis. So you're going to want to make sure you understand what all those things are, both from you from a physical standpoint, your child from a physical and mental health standpoint, because those things can be relevant to a custody case. I think I had one recently where this was a big bucket where we had to present a lot of evidence as to why a parent could take care of these certain needs of the child, how they were familiar with them, knew what this child's specific needs were, and were capable of being the parent that handled those issues. And that's how that figures into a custody case. Another thing is evidence of domestic violence, substance abuse, or neglect. So sometimes there may be a parent that has concerns about the other parent's substance abuse issues, or there could be domestic violence in a home, and that's a big factor because a lot of times if there's a domestic violence conviction or domestic violence in the home and the child's around, that parent may actually have to have supervised parenting time until they do some things to show that they've changed, such as a Betters enrichment program or things like that. So that's a big bucket. But that's broadly what the courts consider when considering the best interest. There's also different types of evidence that you can show that kind of goes into those buckets to make arguments around the best interest of the child. For instance, you may get a guardian ad litem. This is a third party neutral that represents the child's interest. This is typically someone that's an attorney. They would do an investigation. They would go meet with both families, talk to them about what they want for the child. They would investigate the homes. They would talk to the school. They may talk to the child's therapist. They take a broad look and advocate for what they believe is in the best interest of the child. It's of a similar vein. There's sometimes you may get a custody evaluation where a psychologist does the same. You can also get evidence of your own. You may want to get school records, medical records, mental health records, things like that to show what's going on at school or with the child mentally or physically to show why one thing may be in the best interest or another. And then there's also witness testimony. A lot of times there's witnesses who can speak to the best interest. In a custody case, a lot of times I have a grandparent come in who can talk about the parent's parenting capabilities, how the child's doing in the parent's care. A lot of times a grandparent is a very compelling witness in a custody case, but there's all sorts of different witnesses that can speak to these different buckets with regards to a best interest of a child. Next is the role of the child's preference. It's a lot of times someone asks me, can the child talk to the judge? In practicality, it doesn't happen very often. You can request what's known as an in-camera interview, which is a chance for the child to go in and speak with the judge. Sometimes if the child's over 14, the way may grant this. Sometimes they may grant it below, but it really just depends on the case. You see them granted every so often, but a lot of times the courts prefer to see a guardian ad litem who's more of a neutral person who can go and meet with the child in the child's own setting and take a broader look at what's going on with the child, as well as speak with the child and give a report to the judge that the judge considers. But the child's preferences do matter, specifically if they're over 14. So if you have a child over 14, I would definitely, if you think they want to talk to the judge and weigh in, file that motion for in-camera interview so they could talk to the judge. So if you're a parent and you want to strengthen your case, there's a lot of things you can do. Don't just hire an attorney and sit back. Get your evidence together. Go to the school, get attendance records, get report cards. Make sure that they are done in a way where they come into evidence. You're going to want to work with your attorney about that. You're going to want to make sure that if in your home the child has a consistent routine. You're going to want to show a willingness to co-parent, which is basically an ability to work with the other parent. A lot of times these cases can be emotional. There's a person that can get under your skin and make you mad, but at the end of the day, it's about your child. You want to be the bigger person. You want to be professional in these communications and make sure they're about the best interest of the child, because these text messages typically come in and you want to be the person that's working towards outcomes for the child rather than being hostile towards the other parent. And then you also want to address concerns proactively. If the child's sick, you want to make sure you get them into a med check or a doctor. You want to be the person that is addressing these things and putting the child's best interest first. Another big thing is just documentation. A lot of people say I've had the child more this past year, but they have no evidence to show it. You're going to want to create a parenting time journal. I have one you can download on my website, and basically keep data about what's going on with your family. So if you can say they got him late to school on these days, know what days they are, and have the evidence to support it. So you want to document everything going on with your case, because you never know when you may end up in custody court. So you want to have that record going before you need it. So common missteps, I think I talked a little bit about this, but speaking negatively about the other parent. If you are court ordered to do certain things, follow those court orders. If the Indiana Parenting Time Guidelines apply to your case, get familiar with the guidelines so you're following them. A lot of times it's reasonable communication with the other parent when they're in your care, opportunity for additional parenting time. Know those things and make sure you're following those rules. You could also have issues if you aren't taking care of the child's needs, things like that. So those are just some of the common missteps to avoid. When you're in court over a case that's involving the best interest of the child in custody, the courts prioritize stability. One thing I talk about is what's your job history, how long have you been in your home, to show there's that stability. But if there are movements in those two, those also can be explained. Relationship strength, they're going to want to see how your bond is with your child. So I ask a lot of questions around what you do with your child and how you're connected to them and how you connect with them, and to show what your parenting skills are. Parental cooperation, again, it comes down to being that bigger person and being able to co-parent, cooperate with the other parent. Even if they're not, you want to show that you're the one trying to, rather than the other way around. And then if you are dealing with stuff, having an attorney can make a big difference in your case. So I always recommend talking to an attorney, hiring an attorney to help you through this. So if you have questions about a custody case, give me a call. I'd be happy to talk to you about how I think the best interest standards apply to your situation, and if you need changes or are facing a custody hearing, what I could do to help. So here's my number, call or text. I'd be happy to talk.